Welcome to this edition of Cato Connects. My name is Caleb Brown. I'm the Director of Multimedia here at the Cato Institute. Before we get started talking about now two court decisions in the federal circuits on ObamaCare's exchanges, I want to tell you how you can participate in this discussion. You can ask your questions via Twitter using the hashtag HalbigCato. You can also send them to me directly at C.O. Brown. So I'm going to talk now with Michael Cannon, who is one of the people who was responsible for these cases really getting off the ground, and a lot of states realizing that maybe they did not have to comply with a great deal of Obamacare's mandate. So, Michael, based on what you've read today, what do you have to say about these opinions? I know you are more familiar with Halbig, but of course King was also decided today. So, if you can, just give us some of your early thoughts.
Well, the issues are exactly the same in both cases. What's happened in both cases is this. The Patient Protection and Affordable Care Act clearly says, and repeatedly says, that the subsidies it offers through health insurance exchanges are only available through, quote, an exchange established by the state. The statute defines a state as one of the 50 states or the District of Columbia. It also says that a territory that establishes an exchange will be treated as a state. And if a state doesn't establish an exchange, then the statute authorizes, in fact, directs the federal Secretary of Health and Human Services to establish and operate such exchange within that state. But the statute does not give the IRS any authority to issue subsidies through those exchanges. So that's what the federal government did anyway. The IRS announced it was going to do that back in 2011. And those subsidies trigger penalties against individuals in states that opt not to create an exchange. They directly trigger penalties against employers under the employer mandate and indirectly against individuals under the individual mandate. So in Halbig v. Burwell and in King v. Burwell, you have employers and individual taxpayers who said, wait a second, these subsidies that are going to trigger taxes against us are not authorized by Congress. And so we're being injured by that, and we're filing suit.
Okay, here's the relevant chunk. This is the perhaps the nut graph, if you will, from the D.C.'s opinion. We conclude that appellants have the better of the argument. A federal exchange is not an exchange established by the state, and Section 36B does not authorize the IRS to provide tax credits for insurance purchased on federal exchanges.
And the rest of the statute is abundantly clear. The rest of the opinion is really just Judge Griffith trying to respond to all the arguments that both the government and the dissent in this case from Judge Edwards are offering in defense of the IRS's decision to issue those subsidies. And there are all sorts of arguments. In fact, what they're really just doing is throwing a lot of spaghetti against the wall and seeing if anything sticks, and none of it does. None of it has any support in the statute. None of it has any support in the legislative history. They haven't produced a single statement by a member of Congress saying, we intend to offer tax credits through these subsidies through exchanges established by the federal government. And there's ample legislative history, as Judge Griffith notes, to show that Congress was considering using that policy lever. There are other bills in Congress that would have withheld exchange subsidies, even through federal exchanges, if states didn't jump through certain hoops.
All right, so King v. Burwell also decided from the United States Court of Appeals for the Fourth Circuit. The unanimous opinion of that panel said the plaintiffs contend that the IRS's interpretation is contrary to the language of the statute, which they assert authorizes tax credits only for individuals who purchase insurance on state-run exchanges. For reasons explained below, we find the applicable statutory language is ambiguous and subject to multiple interpretations. Applying deference to the IRS's determination, however, we uphold the rule as a permissible exercise of the agency's discretion. We thus affirm the judgment of the district court. This is deference.
Well, right. It's interesting because at the district court level, the government won in both Halbig and in King at the district court level, and those judges held that the statute was unambiguous, that it did authorize unambiguously these subsidies through federal exchanges. So the government has already lost some, even though it won in King v. Burwell, it has lost some ground because the judge said, no, the statute isn't, or the three-judge panel in the Fourth Circuit said the statute is not unambiguously read the way the government says, they say it's ambiguous. But it's not even ambiguous, because there's nothing ambiguous about the term established by the state. The term state is defined, and there's no language in the statute that achieves what the government wants to do, which is to have a federal exchange be treated as though it had been established by the state. There are two parts in the statute where Congress does deem an exchange established by a non-state to be an exchange established by a state. One is in the definition section of state. It says that states include the 50 states and the District of Columbia. D.C. is not a state, and yet Congress deemed it to be a state. So D.C.'s exchange, if D.C. establishes one, which it has, is deemed to be an exchange established by the state. Same thing with the exchanges established by the territories. As I mentioned before, there's that language that says that they shall be treated as a state. There's no such language deeming an exchange established by the federal government to be established by the state.
All right. So from the majority opinion, Halbig v. Burwell, this is 2 of the 3-judge panel, we reached this conclusion, frankly, with reluctance, at least until states that wish to can set up exchanges. Our ruling will likely have significant consequences for both millions of individuals receiving tax credits through federal exchanges and for health insurance markets more broadly, but high as those stakes are, the principle of legislative supremacy that guides us is higher still within constitutional limits. Congress is supreme in matters of policy, and the consequences of that supremacy is that it is our duty, when interpreting a statute, to ascertain the meaning of the words of the statute duly enacted through the formal legislative process. So what are the implications here for people who have been receiving subsidies and for employers and taxpayers in states that are affected?
Well, they're really sweeping. First of all, the Obama administration has been issuing subsidies. What the court has essentially ruled is the Obama administration has been issuing health insurance subsidies in the 36 to 5 million people in the 36 states with federal exchanges with no statutory authority whatsoever. In fact, contrary to the plain language of the statute. So the president has been spending money illegally, is what the court has ruled. If the court if the D.C. Circuit's ruling is upheld and the IRS's tax credit rule is vacated, then those subsidies will disappear. Now, it's not only that. Those subsidies also trigger penalties against individuals and employers under the individual employer mandates. And it's actually a much greater number of people who are exposed to those, who are subject to those penalties, even though they are by law exempt. You're talking about 8 million people. I've conservatively estimated 8 million people are being unlawfully subjected to the individual mandate penalties. And 250,000 employers and 57 million employees are being unlawfully subjected to employer mandate penalties. So if this ruling is upheld, that IRS rule gets vacated, and those subsidies and those penalties should disappear. Now, this is, as the court said, these are major ramifications. This is a very important case with that'll have a lot of important consequences. But the thing to keep in mind is the effects of this case. The fact that they are so sweeping is an indication of just how broad and important and sweeping the Obama administration's illegal behavior is here. They were taxing, borrowing, and spending billions of dollars that they had no authority to tax, borrow, and spend.
All right, let's go to one Twitter question. Our good friend Popat has a question. Will King appellants attempt to move both cases to SCOTUS, thus bypassing en banc review?
I don't know. En banc review is never guaranteed, and a circuit split is a good way to get before the Supreme Court. It may go straight to the Supreme Court, or one of the other courts may grant en banc review. But I think the government has said it will seek en banc review in the D.C. Circuit, Halbig, but I haven't heard any indication from the plaintiffs in King whether they will do the same at the Fourth Circuit.
This is another item from the majority here in Halbig v. Burwell. We begin by clarifying the role that the ACA's legislative history might play in our analysis. Legislative history is a means to an end to be consulted for evidence of congressional intent, but legislative history is not the sole or even the primary source of such evidence. Rather, the most reliable guide to congressional intent is the legislation the Congress enacted. So who's trying to rely on legislative intent? Your argument is that essentially this issue is not about legislative intent, or doesn't have to be, because the statute is clear.
Well, right. If the statute said what the government wanted it to say, they wouldn't have to rely on legislative intent or congressional intent. But congressional intent is not the law. The words that Congress enacts, the bill that passes both chambers of Congress and is signed by the president, that's the law. Congressional intent is a tool for helping to understand or for helping to resolve ambiguities in the law, but there are no ambiguities here. There's no ambiguity about established by the state.
Our friends at the Citizens Against Government Waste ask, what, if any, difference exists between subsidies in the 27 states with no exchange and the 9 states that have partially opted out?
Well, all states have an exchange at this point. 14 states in the District of Columbia have established their own exchanges. 36 states, which is that 27 plus 9, sum of 27 plus 9 there, 36 states have failed to establish an exchange for one reason or another. Either they refused or they tried to do it and it didn't work and the federal government had to take over and establish an exchange. 36 states have federal exchanges, so it's in those states that this ruling would have its immediate impact.
Okay, Jeremy Murphy on Twitter asks us, do we have a circuit split between the Fourth Circuit and the D.C. Circuit interpretations of the ACA? And essentially, what happens next?
Yes, we do, and that helps to get before the Supreme Court.
Okay. We have another question here. And what about an executive order? Do you expect an executive order to be signed?
Well, I've been asked this question a lot. You know, if the Obama administration loses Halbig, is there some sort of fix that they could put in place? But that misunderstands the nature of these cases. Halbig challenges the fix, and what the D.C. Circuit did today was it struck down the fix and said, no, the Obama administration can't fix this. Congress has to fix it.
Okay. From Todd Ruger from, I believe, Legal Times, he says that the White House says that a DOJ will ask for en banc review of Halbig on the ACA. Quote, we are confident in the legal basis that supports our case. This was, of course, a few hours before the King opinion was rendered. Effects?
Of the administration saying that it believes in its own legal arguments?
Like King may be changing their legal strategy.
I'm not sure that it's going to. I mean, the arguments are the same. The administration is trying to find some way that that Congress deemed a federal exchange to be established by a state, and it's simply not there.
Okay, David Lowenthal on Twitter asks us, how many states do you estimate will convert to state exchanges if this ruling is upheld? There's a lot of political considerations to that question as well, right?
It could be as many as 0. You could have some states doing that, but it may be the case that no states do that for a couple of reasons. First, what this ruling does is it frees employers, in addition to ending those subsidies, it frees employers and individuals in those 36 states from the employer and individual mandates. As I said before, 250,000 employers, 57 million employees, 8 million individual taxpayers. Those folks, when the states have this debate over whether they should establish an exchange, those folks will say, wait a second, if we don't establish an exchange, we're exempt from those penalties. So there will be political pressure in addition to whatever political pressure initially led those 36 states not to establish an exchange. You'll have additional pressure not to do it. In fact, you might even have some states that have established exchanges thinking about going the other way and opting for a federal exchange, because if the employer mandate operates in your state but not in a neighboring state, then that could erode your tax base if employers leave.
And, you know, as you say, there are so many businesses that are affected by this. This is a much cleaner question to be put to state lawmakers this time around than it was in the passage of Obamacare, because now if state lawmakers decide we're going to this exchange, they are the ones effectively triggering IRS penalties.
That is correct. Yeah, and so it's going to be a difficult sell in a lot of states, particularly since, and this is another factor you have to keep in mind, the D.C. Circuit just ruled that the Obama administration was breaking the law, was engaging in taxation without representation, was spending money without congressional authorization, and doing all of this to prop up its very unpopular, still embattled, still troubled health care law. What's that going to do to the opposition to Obamacare in those 36 states? Are they going to say, oh, well, we need to make all this nice and legal so the president doesn't have to break the law anymore?
T. Wobbler Mangrove. These are great names.
I believe it's spelled Raymond Luxury Act.
I see. Okay. If this makes it up to SCOTUS, what is your prediction about how this plays out? You've written some items about what you expected Elena Kagan and others to write based upon what they've written in the past.
Well, I don't make predictions.
Okay.
My co-author on these issues is Jonathan Adler, a law professor at Case Western Reserve University School of Law. He and I like to say that we like to joke that the case against the IRS here is ironclad, which means the odds of success in court are a solid 20%.
All right, fair enough. Andrew Calvin Bayard asks on disappearing subsidies. Will the subsidies that have already been paid out be retracted from insurance companies?
Well, that's an interesting question, and Congress has already spoken to the question of what happens if someone gets a tax credit that is larger than the one to which they were entitled, and it is they have to pay it back, or they have to pay a lot of it back. So I think that shows all the more, or really reemphasizes why the president's actions here were so reckless. He was issuing billions, tens of billions of dollars in subsidies to millions of people that he had no authority to issue. Those are subsidies that could disappear with one court ruling, and they're subsidies that once they disappear, those 5 million people might have to pay back under the plain language of the Patient Protection and Affordable Care Act. So there might be some downstream effects from this ruling that are harmful to people, but they're not effects of this ruling. They're effects of the statute that Congress enacted, because that's all this ruling does, is it forces the government to abide by the statute. And they're effects of the government or the president making that reckless decision to spend money, to give people money he didn't have authority to touch.
Richard Hones asks, address the Fourth Circuit opinion that rules against what Michael F. Cannon is arguing is a slam dunk. This is the opinion that basically argued there is ambiguity, despite assertions that there is no ambiguity on the other side.
Someone on Twitter the other day made a really, I thought was a good observation. Depending on who you ask, this case is either so simple that it should be open and shut, or that the plaintiff's arguments are so absurd that they should be laughed out of court. So, the truth is I obviously think it's the former. What the Fourth Circuit said was that this is ambiguous, that Congress, that there are members of Congress who wanted to establish, or who wanted there to be tax credits in federal exchanges, that there's enough wiggle room in the statute that the IRS's interpretation is reasonable, but there really isn't. You can only reach that conclusion if you completely obliterate the difference between a state government and the federal government. And that is just not something that Congress ever empowers the IRS to, or federal agencies to do on its own. There's a very bright line difference in our federal system between states and the federal government.
The president, or at least the White House, has said the subsidies must flow irrespective, without respect to the Halbig ruling. This was before the King ruling came out, which I think would call into question whether or not they would need to stop.
There's usually a period of time after a ruling like this before the courts require the government to end the behavior and put an end to the behavior in question. And I don't think that is passed yet. I don't know really what is legally required of the president in the immediate wake of this ruling. One interesting aspect of this, though, is the president did suggest that he might ignore this an adverse ruling from the D.C. Circuit because the government's attorneys filed a notice with the D.C. Circuit that basically said that a ruling would only bind the parties to Halbig and would not have a broader impact, which is completely contrary to how these cases are decided under something called the Administrative Procedures Act. If you're challenging an IRS regulation and it is found to be contrary to law, the only remedy is the court vacates the entire regulation. And if the court does that, the court is saying that the IRS doesn't have the authority to issue those subsidies. So if the president ignores that, you might have a real constitutional crisis.
So is this void for vagueness? Is that the principle at work here?
That
if there's this great deal of ambiguity that you
the what the Fourth Circuit is saying, and what the government has argued, is that there's sufficient ambiguity that the courts can invoke something called Chevron deference. And under this case, Chevron v. Natural Resources Defense Council, the Supreme Court said that if a statute is ambiguous and the agency's interpretation of that ambiguity is reasonable, then the courts defer to the agency's interpretation. But it's not up to the agency to decide whether there's ambiguity. The courts get to decide that. And if you look at the entire statute and all of the legislative history, even though you don't even need to look at it, but it corroborates, as Judge Griffith in the D.C. Circuit did, there is no ambiguity here. Established by the state means established by the state, and even though Congress could have defined a federal exchange to be established by the state, it did not.
All right. Huck 19 asks, if the government's argument is correct, why would any state establish an exchange? Why put requirement for state-based exchanges into the law?
Well, the Massachusetts established an exchange before Congress called on states to do so. There are other reasons why they might want to do that. The purpose of this, well, I think that the purpose of conditioning subsidies on states establishing exchanges was twofold. First of all, this language came from the Senate Finance Committee. The Senate Finance Committee doesn't have the authority to regulate health insurance, or the individual market for health insurance, as it's called, or health insurance for small employers. And so in order to give itself a jurisdictional hook, it had to condition what it did was it took tax credits, which are in the Finance Committee's jurisdiction, said we're offering these tax credits, but if you want these tax credits, you states have to do what we want you to do in terms of health insurance, such as establishing an exchange, which would otherwise be outside their jurisdiction. But the second reason was, in order to get the bill through the Senate, the exchanges had to be established, or they had to be state-run. There are a couple of Senate Democrats, and they needed every Senate Democrat on board, who wanted the exchanges to be state-run so that it wouldn't be a federal takeover of health care. And the problem there is that Congress can't command states to implement federal programs. What they often do, and did elsewhere in the same bill with the Medicaid expansion, is say, look, states, you'll get these subsidies, but you have to do what we say. And that's so they did that to get around the constitutional prohibition on commandeering, as well as to give the Finance Committee jurisdiction to legislate in this area.
All right. A question from Anderson Strategies on Twitter. Could this ruling have a broader impact on the entire PPACA if it gets to SCOTUS, or would the Supreme Court decide this fairly narrowly? It doesn't. Does it seem like there's an opportunity?
It's difficult to decide this narrowly. You can either rule for the government, in which case you're saying what the IRS is doing is lawful, or you can rule against the government, in which case you're saying what the IRS is doing is unlawful, and the only remedy there is to end the unlawful behavior, to vacate the IRS rule, and those subsidies and those penalties disappear in the 36 federal exchange states. Now, what sort of effects will this have on the PPACA? It's important to recognize that the effects will be from the statute itself. It's not the ruling, it's the statute that's causing these effects. And what would happen is 5 million people in those 36 states with federal exchanges would be exposed to the full cost of their Obamacare exchange plans. And there's a lot of people, in fact, some economists who filed an amicus brief for the government predicted that you would get what economists call an adverse selection death spiral in those states, where premiums go up, healthy people drop their coverage because the premiums are so high, premiums go higher, and the entire market collapses. That's actually what we've seen happen as a result of the PPACA in the markets for child-only health insurance and to the PPACA's long-term care entitlement program, the CLASS Act. So that could be a downstream effect of this ruling, but it's really an effect of the statute itself. It's something that the statute has done in numerous other places, and that is something that Congress would probably have to reopen the statute to address. And I don't just mean as a practical matter. I mean politically, there would be so much of a backlash against those effects of this law that Congress would have to reopen it.
All right, that's going to be it. Thank you very much, Michael, for taking the time to talk with us today. I know you've had a very busy day, and it continues after this. If you have any thoughts or comments on how we did today with respect to this new program, you can email me, cbrown@cato.org. You can talk to me at Twitter @cobrown, or just send an email to pr@cato.org and help us out to make this program better. Thanks again. We'll talk to you next time.